Well, good evening, Federalists and friends and honored guests. My name is Morgan Larson, and I serve as the president of our Federalist Society chapter here at the Sandra Day O'Connor College of Law. And on behalf of our chapter, welcome to the 45th National Student Symposium. For the next 2 days, students, scholars, and judges, and practitioners from across the country have gathered here in Phoenix to engage in serious discussions about the Constitution and the principles that animate it. We are deeply grateful to you that you have traveled from near and far to be here with us. Welcome to State 48. Our theme this year, Liberty Rising, was chosen with both history and place in mind. Named after the mythical Phoenix, our city symbolizes renewal, resilience, and rebirth. It therefore seemed fitting a location for answering questions like, how do we renew the spirit of 76 in 2026? How can foundational principles like free markets, free speech, and federalism be revitalized in modern legal and policy debates? And how do we ensure that liberty continues to rise over this great nation? Thus, the task before us this weekend is not merely to celebrate the past, but to examine the ideas seriously through debate, through disagreement, and through the kind of rigorous exchanges that the Federalist Society was founded to foster. But before we begin, I would like to extend my sincere gratitude to the leadership of this law school, whose encouragement and support made it possible for our chapter to host this event. But I would especially like to thank Dean Stacy Leeds, who enthusiastically supported this crazy idea from the very beginning to bring the National Student Symposium back to ASU. Dean Stacy Leeds serves as our Willard H. Pedrick Dean and Regents Professor. She's a nationally recognized scholar in Indigenous law and policy, a former Cherokee Nation Supreme Court Justice, and a distinguished leader in legal education. Over a career spanning more than 2 decades in academia and public service, she has been deeply committed to fostering leadership, innovation, and thoughtful engagement with the law. We are deeply grateful for her support for this symposium and for the many ways that she champions intellectual exchange at this institution. So please join me in welcoming Dean Stacy Leeds.
Well, good afternoon. It's my pleasure to welcome you here to the Sandra Day O'Connor College of Law. It is also our distinct pleasure to host you again. It's the second time in the last decade that we have had the privilege of hosting this wonderful symposium here at our law school. If you have some free time that's not taken up with the festivities today and tomorrow before you fly back home on Sunday, I do hope that you can make some time to explore our area. Tempe and Scottsdale are just about a 20-minute drive from here, and if you haven't done so, I highly encourage you to get inside one of our Waymo autonomous vehicles and maybe go out to one of our Cactus League Major League Baseball spring training games. Do that if you want a uniquely Arizona vibe during your time with us. We are so honored to have you here and for our law school to be a part of this symposium. Each year, this event gathers together what is, without a doubt, some of the top scholars and leaders and judges, attorneys, and students throughout the country to be here for a very serious exchange of constitutional principles and also discussions about what the future of the law should look like. The fact that this year's symposium is back here at ASU Law is certainly a privilege, and it's also a testament to the strength of our ASU chapter. We had the privilege this afternoon of having an alumni gathering of the Federalist Society students and alumni who have been a part of this strong chapter since its beginning. And this year is the 40th anniversary of us having an active chapter here at ASU Law. In the last 3 years, our chapter has been recognized with 2 national awards, including the Chapter of the Year, and then, of course, getting your endorsement to have the event be here hosted and visioned by our chapter. So I want to start by thanking the extraordinary efforts of the students in this law school that brought this to fruition. And I, too, want to give my gratitude and thanks to President Morgan Larson for her leadership this last year. In this organization, we have students that aren't just strong students for this chapter, but the students in this chapter are the leaders of our entire law school. They make this law school a better place, and working so closely with this chapter and with Morgan, it has certainly made me a better law dean. So thank you for that. So I want to echo a little bit about the theme for this symposium: Liberty Rising, the rebirth of free markets, free speech, and federalism, and especially fitting that it be here in Phoenix. Our city, of course, takes its name from the mythical bird that rises out of the ashes and symbolizes both renewal and resilience. That image, of course, serves as a powerful metaphor for the enduring vitality of our Constitution and its importance in American life. As we do proceed this year with celebrating the 25th anniversary of the Declaration of Independence, a document that, of course, said to the world something bold at that point, and that being that liberty and self-governance and the rule of law, first and foremost, belongs to our people. So for the last 250 years, these ideas, of course, have shaped our Constitution and our institutions, and also our ongoing debates about what liberty means and how we go through the process of preserving and protecting it. The conversations that are on the agenda to take place during this symposium are part of that enduring dialogue. This is also a very important year for this law school. 2026 also means that we'll celebrate the 20th anniversary of the naming of this law school after Justice Sandra Day O'Connor. In 2006, after she retired from the United States Supreme Court, she gave us her blessing so that this law school would be named after her into perpetuity. And that didn't happen on the heels of a multi-million-dollar donation that usually couples with the naming of a law school. It came because it was something that we wanted in terms of celebrating her legacy and her commitment to judicial ethics and her commitment to the rule of law. But it's also something that she allowed, with the understanding that a top public law school in America should be an important part of preserving democracy. And so we take very seriously our role of growing the talent and producing the lawyers and leaders that will ensure our democracy. Justice O'Connor remains the only modern-day Supreme Court justice that served in all 3 branches of government at both the federal, state, and local level. So a little bit about her background so that you can help carry her legacy on as you go back and talk to people about her. She first served as an attorney representing the executive branch here in the state of Arizona when she worked for the state's attorney general's office. She later was an elected official in the state Senate here in Arizona, and she first broke ceilings in terms of being a woman trailblazer because she was the first woman in the United States to ever serve as a state Senate lead. And she served as the leader of the GOP for the Senate here in Arizona as an elected official. And then you know the rest of her story. After she served here in this state on our state's Court of Appeals, she was then nominated by President Reagan and served in the United States Supreme Court, being the first woman to do so. Now, she remains the only woman to be an attorney and a judge and have her name attached to a United States law school. She also has her name on our federal courthouse building here. And I think that it was extra special that both of those namings happened when she was very much still alive and active in our legal profession here in Arizona. So it was very frequent to have her physically here at the law school. When this building was built, there's an office in the dean's suite where she still kept an office. And as her time here in the law school, often, coupled with her being here talking very casually and randomly to our students that she would see in the hallway and attend events. And what she always imparted to our students and our faculty then is that the United States Constitution and how it continues is much, much more than just an academic conversation. But instead, it's both an intellectual conversation, a conversation about how to interpret text, and also a conversation about pragmatism and the understanding of how local and state governments work and sometimes conflict with the federal government and federal power. So over these next few days, you're going to hear some dialogue from distinguished speakers, and also you will engage in some of these conversations, important conversations about legal and policy issues that are facing our country today. My hope is that these conversations will challenge you and inspire you and prepare you to carefully and thoughtfully go about your work and the work that's coming in the future years as you enter the legal profession about what you're going to do to preserve and strengthen our constitutional system. So with that, I just want to extend my gratitude to each of you for joining us and hope that you have a wonderful time here in Phoenix. And I also wish you a very thoughtful and inspiring symposium. Thank you very much. And with that, I'm going to yield the podium to Elizabeth Ness. Thanks.
Thank you all for being here, and I'm here to get our first panel started. So with us today, we have some very distinguished panelists and moderator to kick us off with Laboratories of Liberty, State Deregulation and Economic Freedom. Economics are a critical element of federalism. Principles of unrestrained trade and the right to work are embedded in state constitutions and in the enterprising spirit of the founding. After all, it has been said that a wise government should leave men free to regulate their own pursuits of industry and improvement. Today, states are the proving grounds for economic freedom and regulation. We are so fortunate to have this distinguished group of panelists with us to unpack these issues. They each bring unique experiences and expertise, and will explore how state-level deregulation efforts are shaping a national conversation about liberty. To guide the discussion and to introduce them to you, I am pleased to introduce our moderator, Judge Liburdi. He is a United States District Judge here in Phoenix, Arizona. He was appointed to the bench in 2019 by President Donald Trump. Prior to his appointment, Judge Liburdi practiced law at 3 major firms here in Phoenix, and he also served as general counsel to Arizona Governor Doug Ducey during Governor Ducey's first term in office. So with that, I'm going to hand it off to Judge Liburdi. Thank you.
Thank you, Elizabeth. Thank you, everybody. Thanks, Elizabeth. Thank you to Morgan, Dean Leeds. Thank you for hosting this wonderful event. Justice Clint Bollock of the Arizona Supreme Court is here. I wish to acknowledge him. And I saw Circuit Judge Anthony Johnstone somewhere. I hope he's still here, but he is present. I'm going to introduce this panel, but first what I wanted to say in somewhat of an introductory manner is, despite being a federal district court judge, my favorite job that I've had was being counsel to Governor Doug Ducey. As his chief counsel, every day was different. You met so many people, solved so many different people's problems. And when I joined him in January of 2015, one big issue that was before the new governor and his staff was the regulation of rideshare. So today, 11 years later, we very much take for granted that you can just get on your phone and summon a drivered car or a driverless car. But when those technologies were emerging way back then in the early part of the 2010s, there was quite a bit of a reaction from the existing transportation companies, namely the taxi companies. So Governor Ducey and his staff were being asked, to somewhat shoehorn the regulation of rideshare into the existing statutes, those statutes existing for taxi cabs. And I recall somebody making the argument that the cell phone being used by the driver is the equivalent of a fare box, and therefore Uber, Lyft, et cetera, were subject to the taxi regulations. Well, that happened to be resolved differently, and I'll let others on the panel discuss that in more detail. So, others on the panel. Paul Avelar is here to my left. Paul is the managing attorney for the Institute of Justice's Arizona office. He began that position in March of 2010, and he litigates free speech, property rights, economic liberty, school choice, and other constitutional cases in both state and federal courts. Paul clerked for Judge Robert Minor on the Second Circuit Court of Appeals. He also clerked for then Justice Andrew Hurwitz on the Arizona Supreme Court, and of course, Justice Hurwitz is now a judge on the Ninth Circuit Court of Appeals. And he also clerked for Judge Daniel Barker on the Arizona Court of Appeals. Paul graduated from ASU College of Law, and he has an undergraduate degree from Princeton University. Next, Danny Seiden. He is president and CEO of the Arizona Chamber of Commerce and Industry, and he has more than 16 years of experience in global public affairs, government relations, and complex legal matters. He was a shareholder at the Greenberg Traurig firm here in Phoenix, and he also served in government relations and general counsel roles for private companies. From 2014 to 2018, Danny was Deputy Chief of Staff for Arizona Governor Doug Ducey. I actually think that should be 2015, right, Danny? He doesn't know, 2015. Danny earned his JD. Danny didn't write that. Danny earned his JD from ASU College of Law and his bachelor's from Pepperdine University. Next is Professor Jennifer Selin. Professor Selin is an associate professor at the Sandra Day O'Connor College of Law. Her scholarship employs legal analysis and empirical tools, exploring legal institutions and the consequences of administrative decision-making structure on policy implementation. Her scholarship has been utilized by the Obama, Trump, and Biden administrations, Congress, the United States Supreme Court, and the media. Professor Selin holds a JD from Wake Forest University and a PhD from Vanderbilt University, and she is also a proud graduate of Lebanon Valley College. And finally, we have Attorney General James Uthmeier of the great state of Florida. General Uthmeier previously served as Chief of Staff to Governor Ron DeSantis, and he also served as General Counsel to Governor DeSantis, where he oversaw litigation and judicial nominations. He served as a senior advisor to the United States Department of Commerce, that is, and he began his career as a litigation associate at the Jones Day firm. He's a Georgetown Law grad and a University of Florida graduate. Okay, well, what we're going to do is each panelist is going to speak for about 7 minutes, and then I will begin with some questions for the panel, and with the time remaining, we'll turn the questions over to the audience. Paul?
Thank you for having me. It's great to be here. I sue the government for a living. And so I think everyone else is going to talk about all the ways in which government can improve itself and really make strides in policy to protect economic rights and economic liberties. I'm here to tell you that's all nonsense. The best way to do this is just sue the government. One of the many failures of the modern law school is its real disinterest in teaching state constitutions. Con law typically in law school is taught only through the federal prism. Don't let me mislead you. That's really important, says the guy who also litigates in federal courts under the federal Constitution. But it's only half the story. It's incomplete. Every state has a constitution. Some of them predate the federal constitution and serve as models for what is now in the federal constitution. All intentionally make different textual choices from the federal constitution. All of them contain provisions that have absolutely no equivalent in the federal constitution. No state court is bound by any federal decision about state law, and therefore, state constitutions can be, and oftentimes are, far more protective of individual rights than is the federal constitution. So, as Judge Jeff Sutton and too many others to count now have noted, that if you're representing a client in a constitutional law case and you're not doing state constitutional law together with federal constitutional law, you're giving up at least half your arguments, and maybe the better ones. So we should be thinking more about state constitutional rights, especially with regard to things like economic liberty, the right to earn a living. The federal story, I think we've all been taught, at least this is the story that I was taught back in law school, more years ago now than I care to admit, that at the beginning of the 20th century, there were real judicial protections for economic liberty. You know, everyone says Lochner, but it wasn't just Lochner. There were lots of cases that said, no, the right to earn a living is a real right. It gets real judging in some way, shape, or form. Then, of course, you had the beginning of the rational basis test in the 1930s with cases like Nebbia or Caroline Products. And even those cases, quite frankly, weren't all that bad. The court was still overturning regulations that were truly abusive of the right of economic liberty. And then in the 1950s, specifically 1955, you get the case of Williamson v. Lee Optical, and here you should all be booing and hissing, which turned the rational basis into the rationalize a basis test, which said that facts don't really matter, reality doesn't really matter, even advocacy doesn't really matter. We're going to say that judges have an obligation to invent justifications for economic restrictions, and that's the world in which we have all been living and learning since 1955 and 2004 when I graduated from law school. And I think even today that's the sort of commonality of what's been taught, unless you're a student of Randy Barnett, in which case you probably get a very different history. But that's what it is, and it has led to some utterly ridiculous decisions. This is where I list my series of losses in the federal court under the rational basis test. I lost a case in the Eighth Circuit with regard to the licensing of hair braiding, where the state said we require you to have 1,500 hours of training, and we admit that no more than 100 of those hours are in any way, shape, or form relevant to braiding. And the Eighth Circuit said, good enough for government work, rational basis, we're good. It's been used to justify some utterly stupid things. We lost a case in Louisiana regarding the licensing of florists, the only state in the country that licensed florists at the time. The basis of the loss was that, well, florists might run into infected dirt someday. Had infected dirt ever been a real thing? No. Did anything in the licensing regime test on infected dirt? No. Had anyone heard or uttered the phrase infected dirt prior to the trial court judge in that case inventing it? No. And we still lost. Indeed, there are a couple of circuits that have recognized that purely economic protectionism, that is, regulating a field to just for the economic benefit of certain participants in the market, is a legitimate use of the government regulatory power. So you have this series of cases under the rational basis test, which really make it very difficult for you to assert your economic liberty rights in federal court. But in state court, maybe that's not the case. At the beginning of the 20th century, all across the country, in state and federal courts, everyone was following traditional tests for economic liberty that were really protective in ways of economic liberty. This is the real and substantial test, this is reasonableness inquiries. These were really, I think, fact-bound inquiries into reality as it exists in the real world and not as it might be theorized by a judge. And indeed, many state Supreme Courts over the years have expressly rejected following federal law, or what's called lockstepping, a term you may not have heard before, lockstepping their constitution, their state's constitution, to the federal constitution. Just because the U.S. Supreme Court makes a dumb decision doesn't mean that we have to follow it with regard to state law. Others, unfortunately, fell into the trap of lockstepping. I think there's lots of reasons for that. Failures of law schools to teach state con law, failures of imagination of lawyers to really be thinking about these things. And so for a couple of generations, it seems like state con law was lost until, and here I'm going to say a kind word about Justice Brennan. In 1977, he wrote a law review article that was all about individual rights under the state constitutions. And Justice Brennan wasn't exactly a fan of economic liberties. We know that from his tenure on the U.S. Supreme Court. But ever since his law review article, people like me and others have been using state constitutions, the independent protections for state constitutions, to litigate for more protection for economic liberty under the state constitutions. As I said, some states have said all along, we're not doing that. Other states in the last 10 years, Texas and Georgia being two great examples, have actually re-embraced their state constitutions and said, actually, no, that federal law isn't a good explanation of what our state economic liberty law is. Our tests are more searching, they're frankly better, and that's the direction they're going to go. So these days, if you are like me and you litigate economic liberty for a living, your first turn ought to be to state constitutions and maybe, and really focusing on there. And to that end, and here I have to be a little bit careful, 3 days ago I had the privilege of getting to argue one of these cases to the Arizona Supreme Court, which used to have a really robust body of economic liberty protections. And then starting in the 1970s, the court just sort of faded away from that. This isn't just me saying what the case is about. I wrote a law review article about this a decade ago, and I'm finally excited that someone has to read it now. In the 1970s, they sort of began to fall away from that, began a lockstepping approach with the federal constitution. Economic liberty rights were lost. And so 3 days ago, I got to go to the Arizona Supreme Court and say, you guys need to fix this. Your predecessors in office, frankly, blew it. Here's the history and the tradition, the original understanding of economic liberty under the state constitution. Here's what it means. Here's what the tests are. Those are not rationalized basis as we know it under federal law. And it's time to get back to the original meaning of the Arizona Constitution. So for those of you who say working with the government is fine, I can do that. I have to do that sometimes too, I confess. But if you prefer suing them, as I do, look at your state constitutions. Look at whether or not your state courts have followed their own path, have really reinvested in the state constitutions, and know that there are greater protections there for protecting economic liberty and other individual rights than you may find under the federal constitution. And if you're not doing both of those things as an advocate out in the world, you are not doing your job to your fullest. And so thank you again for having me, and I hope if you have any questions about state constitutions or suing the government, please raise them with me during the questions. Thank you.
Thanks, Paul. Danny?
Thank you so much. And I guess when AI was writing that intro, it left off probably the most important part of my bio, and that I was president of this chapter of the Federalist Society, I think back in 2006, 2007. So there's that. And it's a perfect segue because probably the biggest fight we had back then was kind of pushing out libertarians versus, true conservatives back in the day. So to go from Paul to I is a very great segue. And Paul spent a lot of time talking about his role outside government and suing government and how effective, or judging by his losses, ineffective that can be sometimes. I'm going to tell you a little bit of a different story, and that is, dating back to the times of the Old Testament, some of the most effective ways to get change and be effective is to do it from within government. And a few of us up on this panel have lived that and experienced it. And why I have a ton of experience and currently serve as the representative of the state's largest business advocacy group, representing all businesses, large and small entrepreneurs, small businesses, et cetera. I want to talk more about my time as Governor Doug Ducey's Deputy Chief of Staff and Campaign Manager, and kind of what we saw and why we made the decisions we made, and the result that we're living in right now. And starting, I'll work off Judge Liburdi's opening story of rideshare. When Governor Doug Ducey won in 2014, going into 2015, Arizona was actually hosting the Super Bowl. And myself and a few others were in charge of transition. That's where you interview all the agency heads and make your decisions. And Governor Brewer was a Republican, Doug Ducey was Republican. We weren't sure if there'd be a ton of transition initially, but quickly found out there would. And a good example is the Department of Weights and Measures, which is who regulates taxis and livery, as it's called in Arizona. And during our transition interview, the gentleman who ran that agency came right out and said, we are going to be so flush with cash. We have all these stings set up to get all the Uber and Lyft drivers operating illegally. We're going to get them, and we're going to line up the state's coffers with it. Well, Governor Ducey gave him an opportunity in the private sector almost immediately, and he no longer worked for us. And that was the start of it, because, again, I worked for a governor who was going to embrace being innovative, embrace disruption. And we did it in all capacities. I know we're going to talk a lot today about regulations, the regulatory state. When Governor Doug Ducey came in, I believe initially we formed a regulatory review council. We eliminated 3,300 regulations off the top. And then he signed an executive order that said for every new regulation someone wanted to come up with, you had to eliminate 3 old ones, which became kind of a theme for him. He wanted to make it so every time a legislator wanted to pass a bill, they had to eliminate 10 other laws. It's just how he felt about things. That didn't work, but the regulatory one did. And again, it yielded such great results for us. What started with just that rideshare mentality led to where we are on autonomous vehicles. The dean mentioned at the intro that you can hop in a Waymo and go over to spring training. Well, if anyone wants to know how that happened, I will tell you right now. We're the first state in the country to allow for testing of autonomous vehicles. And there was nothing easy political about that, because there was always going to be an assumption there'd be some kind of accident, potential fatality, despite the fact that as I'm giving this talk, probably 10 people will cause fatalities because they're looking at their phones or driving distracted. That's the reality. But Governor Doug Ducey believed that it would lead to safer drivers. It would lead to more connectivity. It would lead to not needing parking garage. I mean, all the thoughts that he had, and we were kind of laughed out of the room often, called the Jetsons, that we're going to have driverless cars running around Arizona. To this day, when we host people and we put them in Waymos, they're still like surprised and caught off guard, but it's the norm now for those of you who live in Arizona. Everyone uses Waymos. I use Waymos for my kids to send them to the mall, to send them to practice. It's some of the safest things you can do. And I should have used a Waymo. If you saw me crutching around down here earlier, I might have been avoided blowing out my calf muscle. But no, all joking aside, this regulatory review really worked. And I can remember, these key moments in time where we made these decisions, where California was piling on the regulations on Uber as they wanted to get into the self-driving vehicles. We put out a sign off the executive tower just down the street here saying, if you're not welcome in California, you're welcome in Arizona. And we rolled out the red carpet for them. That came in. Google and Waymo came in. More and more innovation, more and more investment, more and more jobs. But again, Arizona's reputation on our side as this innovative state, on their other side as the Wild West and, putting people's lives in danger, was always in conflict. But I give Governor Doug Ducey and his team a lot of credit for staying the course. And now you're living in it right now. And what did that yield for us in terms of advanced tech manufacturing? I don't know if any of you know this, but you're sitting in the fastest growing manufacturing state in the country right now. The county you're in right now is now making the most advanced semiconductors in the world at TSMC. That did not happen by accident. Again, it's all about this regulatory environment that you foster here. And again, it's not just semiconductors. Aerospace and defense, we're third now in the country when it comes to aerospace and defense. Arizona has just grown substantially. And a lot of that ties back to the regulatory environment that we sought to create. Governor Doug Ducey used to quote Walter Wriston all the time. He has this great quote, "Capital goes where it's most wanted and stays where it's most welcome." And that was the policy matters approach we took to government. And again, we did a lot of great things. My members at the chamber now are enjoying that. And the growing state economy that you're seeing in is enjoying that. Our state budget when we first took over was $9 billion. Now it's up to $17 billion. We have just grown so much in mostly good ways. There's always some challenges, but in mostly good ways. And we wouldn't be able to do that without, I have to mention in my 7 minutes quickly, occupational licensing as well. Another big, when people speak about Governor Doug Ducey and his accomplishments, they usually talk about universal school choice. We were the first state in the country to go for universal ESAs. But really, if you ask me, and I don't know if Governor or Judge Liburdi would feel the same way, we would probably say universal licensing reform was something we did that no other state had done. We recognized licenses from all 50 states, regardless of reciprocity, to let people know in Arizona there was no barrier to entry to work. and it yielded huge success. If I were to ask you a show of hands, ALEC, the American Legislative Exchange Council, ranks states on different categories. Do you know what state is number 2 in the country for the labor market? It doesn't matter because Arizona is number 1. It's so good to be number 1 on that, and that was created by Governor Ducey. I know the gentleman from Florida might say something, but they're ranked number 5 on that. So we have done such a good job fostering that environment here. And I should tell you, I'm a homer when it comes to Arizona. I'll brag about Arizona all day, every day. And a lot of it was things we got to work on together in that governor's office. But since you brought up hair braiders, I will say we didn't always win. The biggest loss, I think, of my entire career was an attempt to allow for what are called Brazilian blow dry bars. I don't know if you're familiar with these, where you can just go get a blow dry. Apparently that violated what people thought was licensing requirements, and we could not win at the legislature because of how powerful that lobby was of the beauticians and cosmetology schools. They were by far the nastiest opponent I have ever encountered in my entire political career. And we've changed the Clean Air Act in Congress. We've done huge things. I fought environmentalists, but the beauticians were by far the toughest opponents I've ever had. And that's how tight people will hold on to these monopolies. That's how tight they'll use the legislature and government to guarantee them a competitive edge in the marketplace. And that's the stuff that we should all find offensive. It should be offensive to our soul. And we're grateful for the Federalist Society for raising up great young talent to come help us in this fight. I know my members love it. I know that as a lawyer, not anywhere near as good a lawyer as anyone else you'll hear from today, but as a lawyer, I appreciate the skill, knowledge, and ambition you all bring to the table. And thanks for having me today, and look forward to answering questions later.
Thank you, Danny. Professor, would you like to go next?
Sure. So I'm honored to be included on this esteemed panel, and I'm a little bit of an odd duck in that I study federal administration and have spent my time exclusively in federal service. So I was thinking about what my perspective could bring to the larger conversation. And so I'm going to build upon the insights of my panelists from the perspective of a public administration scholar. And that includes the need to think carefully about the who, what, when, where, whys, and hows of deregulation. So basically, I'm going to focus on deregulation conceptually and try to tease out what does that actually mean. And I'm going to use my experience both in federal electric market regulation, which is what I worked in right out of law school, as well as my later service in the federal government working as a senior attorney advisor for the federal agency that advises other federal agencies. So literally very meta and kind of the opposite of this panel, right? Deregulation in states. So first, what is deregulation? And I spent a fair amount of time this week thinking about that, and I ended up coming with an interdisciplinary perspective in that if we really think about what we mean by deregulation, it's often that we want to reduce unwanted government restraints on private conduct by intentionally changing existing statutory or legal regimes. And then that raises the question, well, who pursues it? And this panel is an excellent example of the variety of actors who work within deregulation. Because by definition, or at least the definition that I just provided, regulation originates in the law and then is typically elaborated upon by the administrative state, the actors involved in deregulation are quite numerous. Deregulatory efforts can come from all three branches of government, as well as calls from the constituents that those government actors represent. And these efforts are not exclusively Republican or Democratic. For example, at the federal level, I've personally witnessed presidential administrations of both parties announce high-profile deregulatory efforts, albeit in different economic sectors. And what the general underlying feeling of these deregulatory efforts is this idea that the social costs of regulation far outweigh the benefits. So proponents of deregulation question whether in today's political and economic world, outmoded and excessively burdensome government policies can really be revised in a way that reflects current markets. And this logic calls for free markets to provide more benefits. Oh, sorry. Free markets can provide more benefits to society than regulated ones. And in large part, this is because the incentive structures that those markets generate create a potential for the private sector to engage in self-regulation. So things like liability law, for example, can be used to supplement these market-based incentive structures. But ultimately, this logic suggests that the private sector can be innovated, like, say, for example, the Waymo example, and responsive without the need for government to resort to regulations, which can be over-inclusive or create unnecessary red tape. Now, for the sake of my remarks, I'm holding this underlying logic that I just laid out constant. So put another way, I'll let you all debate the validity of that logic, but I'm instead going to push you to think about, well, what happens next? The biggest challenges of deregulation are to first identify where and how regulation has stopped being, on the whole, beneficial. Second, the specific changes that will enable policy to serve the public interest under contemporary economic conditions. And third, to anticipate specifically how governance will change under deregulation. And it's this latter point that I really want to emphasize. Deregulation requires a complex, as was suggested by the comments before me, understanding of the relevant economic sector and the role, both positive and negative, that existing regulation plays in it. This means acknowledging the values of any particular regulatory scheme and how the regulatory scheme was designed to protect those values. Then assessing whether those values are still necessary or relevant and or served by government action. And so as I look forward to our conversation, I'll just note one thing that's a personal hobby horse of mine, is that 80% of federal laws actually construct regulatory partnerships with state, local, tribal, and territorial governments. And if you don't believe me, I have the empirical analysis to back this up, including an analysis of the entire US Code. And this has severe consequences for how we think about any discussion of state-based deregulation. Because deregulation is going to affect, in positive and negative ways, that state's relationship with the federal government. And will do so in ways that are often underappreciated when a state embarks upon deregulatory efforts. So with that, I will let my fellow panelists talk.
Thank you, Professor Selin. Attorney General Uthmeier.
First of all, it's great to be here in Arizona. Great to see everybody. Thank you for having me. I'll start by saying this. My office has had several complaints on these Waymos that are being deployed in Miami, and somebody sent a video, and the car has pulled over. It's kind of shaking back and forth. It's yelling at the passengers who are in the back seat to stay away from the steering wheel. They're in the back seat, and they're yelling like, "We're not touching the steering wheel. Just let us out of the car." And then it proceeds to go into oncoming traffic. Nobody was hurt. Glitches will happen. I'm sure, there will be advancements. I'm not going to be getting in one tonight, so I'll be hitching a ride from one of you guys. So, I believe, and it's become especially true, in the last, 15, 20 years, that the state attorneys general have really become the true defenders of individual liberties, and the states have been the battleground for liberty. And as the founders, intentionally designed the separation of powers and the structure of federalism, preserving what is left to the states, they did so not to protect the branches of government, the institutions, the chambers. They did so to check one another in order to protect liberty. So I think the AGs today in the emerging world and the advancements of technology become ever more important to step in and protect consumers where there are unregulated areas and people getting hurt. The goals of the Attorney General are really to, protect our most vulnerable. In Florida, that really, falls into two key categories: our kids, which I'll talk about in a minute, and our seniors. We have a lot of elderly, a lot of retirees, that are so sweet and kind and selfless and unfortunately get taken advantage of quite a bit by contractors and predators, and there's these new like crypto devices at gas stations, and somehow the seniors fall victim to spam calls and texts, pretending to be family members, and they go and put money in these, crypto ATMs that get sent off, overseas. And I didn't fully get it when I first started hearing these complaints. I called my grandma. I'm like, "You're not like trading crypto, are you?" Because like I'm not even doing that. But it just again the advancements of new technology. Over the last, 7, 8 years in Florida, under the, leadership of Governor DeSantis, we have gotten rid of, I think, every abuse of regulation at the state level that we can. We likewise did one of these, if you do one new rule, you got to get rid of 2 or 3, following, what the Trump administration did in the first term. Scrapped, another couple thousand rules from the books, and saw things like agencies required to spend millions on gloves to handle, the original certificates of incorporation and things that 99%, are now done online. So I think that healthy review of rules over time is important. We created a new office that all new rules have to go through, and there's a period of time during which that Office of Regulatory Reform and Review can ding rules, send them back if they don't believe they're narrowly tailored or the most cost-effective. And then we implemented sunsets, where absent some very special conditions, rules would lapse in 3 or 5 years, and you'd have to come back and re-up them for another term. As a result, Florida's the #1 state economy, more business openings and growth than any other state in the country, largest state GDP, largest classical school, charter school, private school market. Yes, Arizona did pass the bill on school choice first. I'll give you that. However, ours was a 3-year plan that started with a growing number of vouchers, and we actually had the money to fully fund ours in perpetuity when it started. So I don't know where you guys are yet, but we are fully universal, fully funded, including for homeschool families, between 9 and 10,000 a student that can be directed by parents to the school that best meets the needs of their kids. And I want to point out something on the school choice front. We roll this out, and immediately local governments are trying to get in the way, driven by school districts and the powers of the teachers' unions. And we had to come in and preempt and deregulate the access for parents to take advantage of these incredible opportunities. We also made it easier for some teachers to get in the classroom. There were all these regulations that required additional schooling, and we found certain occupations, if you're a veteran in the military or you're a retired cop, we found ways to get you in through apprenticeships instead of the kind of more antiquated education. Immediately we see violence and crime in schools going down, and again, the performance of the students going up. Right now, we're noticing a unique trend as the number of kids that take advantage of school choice and pursue charter schools, classical schools, religious schools go up. We are seeing an almost identical drop in violence amongst young teens, adolescents, and juvenile cases. And it almost exactly parallels. Now, there's a lot of other reasons I'm sure at play with heightened penalties for crime, the shutdown of the border, again, our economy doing very well in the state and attracting, new successful families. But I really believe there's something there that as school choice gets deployed, we are seeing kids make better decisions, we're seeing less violence, and we're seeing more people prepared to go on and raise kids in God's image and set them up for success. On the consumer front, where there's going to be regulation, I present that I believe it's most appropriate at the state level. There are some things, yes, that in the big tech realm, it would be better to have national regulation that treats everybody the same way. But where there needs to be regulation, I think the states are the more appropriate place. Your state legislatures meet more frequently, tend to get more things done, are more accountable to communities of unique interests. I tell you, in Florida, we certainly don't want somebody from California, up in D.C. deciding how we're going to govern ourselves. The areas where we're actively engaged in my office, drugs, obviously. Today we see all kinds of new things that are not regulated, hemp, kratom, there's like a new leaf every day, vape pens coming from our foreign adversaries. We implemented an emergency rule to make this new product called 7-OH, 7-hydroxy, a prohibited drug in the state of Florida. Previously, minors were buying it off of shelves and gas stations, and we immediately saw all of our counties experiencing adverse health effects in hospitals as a result. States need to have the tools, the flexibility to step in these times that are more emergency in nature. I'm a limited government guy. I think government should stay out of business behaviors except where truly appropriate, and protecting our kids is one of those areas. In the last year alone, we have arrested over 1,400 child predators, making this a big initiative. Over half of these encounters began online through social media applications like Instagram, Snapchat, Roblox, Discord, and you see the conversations move sometimes from one platform to another as predators pretend to be kids, use fake photos, tie into insecurities, and then ultimately move to Discord and Snapchat, areas where they don't think law enforcement can track the communications as easily, ultimately soliciting some pretty horrific things, pornographic content, and in the worst of cases, physically abusing kids in person. This is a big problem. There's not enough regulation. We have brought civil and criminal actions against several of these bad actors. Again, this is an area where we need regulation, and if no legislative body's going to do it, I sure as heck hope our AGs out there will use their consumer powers to fight alongside me to do this. We've seen the advantages of not having, heavy regulations during times of emergency in Florida. When there's a hurricane, we can suspend rules, and it's amazing how much faster you can work. The engineers love it. In Hurricane Ian, we put 3 different teams on this bridge that was washed out, and they rebuilt the thing in 3 days. So when you don't have all the code reviews and this and that, and you let the engineers go do their job, they can work wonders. Now, do we want unsafe bridges ever? No. So I understand why the standard practice is going to be a little bit more in-depth, but it shows what can happen when you let ingenuity, run wild. During an emergency condition, we also built Alligator Alcatraz, an immigration detention facility, in 8 days. It was supposed to be built in a few more days than that, but the president wanted to launch it on a certain day, so it was built on a certain day. Going forward, to leave a few big thoughts, I see some kind of far-reaching dreams in how to further protect states' rights and fight back against the overpowering of the federal government and the administrative state that I do think has infringed on individual rights. The far-reaching one would be the repeal of the 17th Amendment to bring back the appointment of senators from the state legislatures so that they're more accountable to our state leaders, less so focused on national interests, federal lobbyists, staying in power, increasing federal spending. But 2 that I do think would be possible in our lifetime would be, ballot amendments, constitutional conventions focused on term limits. We now have, I think, 38 states with term limits for governors. It's becoming very popular in bipartisan fashion. And again, that would be something that would return Congress more to the will of the people in the states and less of national interest. And finally, having a balanced budget. In Florida, we only have one thing that our legislature is required to do by the Constitution every year. It is balance a budget. As a result, we have a budget that's less than half that of New York, even though we've got a larger population. We've paid down our state's debt by half over the last 6 years. We've got a record-setting surplus reaching $20 billion, which is not necessary and is going to be the way that we help offset property taxes and find a way to abolish those, for once and for all and actually make homeowners true homeowners. So with that, I'll wrap it up and look forward to the discussion. Thanks again for having me.
So let me throw a question out to the panel here based on some of the comments of the Attorney General. I think he identified some legitimate policy objectives that states and local governments may have in enacting regulations, and those include public health and safety, consumer protection, and something that I don't think he mentioned, but I think is important is standardization. So you want to have one type of a plug instead of a dozen different types of plugs or that sorts of thing. Standardization is very important. So let me ask the panel: how do you draw the line between legitimate uses of regulation and what might be excessive?
I'll start. I think an easy way to do that is crazy idea, the government could say what it's trying to do, and then you could look at the regulation that it has imposed, and then you could ask this crazy question like, does this regulation actually do that? One of the concerns that had motivated a lot of the early case law on the right to earn a living was specifically the recognition that the police power, that is the power to regulate for public health and safety, was subject to what we would today in public choice economics call regulatory capture. That there are very interested economic groups out there who really are interested in their own wallets, less so about public health and safety, but they're willing to say public health and safety in order to get what they want, the sort of regulation that they want, because regulations tend to be, not a surprise here, geared towards those who are already in an industry and tend to have the effect of keeping new entrants out. This drives down competition, drives up prices. I probably don't need to explain that to this group of law students, though generally I have to do that. So just treating the right to engage in a business as a legitimate, an actual right in the first instance, and then actually doing a little bit of critical thinking about what it is. I'm not going to sit here and tell you I'm against every regulation. There are certainly some that are very good, and I'm glad that we have them, but those are the ones that tend to be actually focused on doing the thing that it says it wants to do in the first place, rather than pretending to do that in order to get something else.
No, I would just build on what Paul just said. I mean, I think you have to really make sure they're justified. And I'll go back to the examples I started with in my intro, starting with the blow dry bill, right? The justification for why they needed licensing and training was that you could burn someone's scalp with a blow dryer, as if you can't do that at home or anywhere else. But that's why you needed that 115 hours and why the beauty schools had to make it. I think it was really easy to sniff out there was a monetary interest in making that, blocking the barrier to entry for people to open up these blow dry bars. If I were to go into the rideshare, which is becoming very popular, to say the biggest fight we had was with the taxi drivers. The taxi drivers did not want the ride shares to come in because they had spent money to get their medallions and they didn't want that competition. Rather than competing by embracing it and becoming rideshare drivers themselves, that was the fight that we initially had. It was really easy to sniff that out. And I would just, because I feel like I have to respond to facts here, if you want to talk about taxi drivers and you think the example the Attorney General gave of the Waymo in Miami, get in a taxi in Miami and see if you get yelled at, see how that experience is for you, see if you think you're safe. You can always pull out the one or two examples, but by and large, you're much safer in a Waymo than you are with the taxi driver. I didn't expect to have to debate that up here today, but nor did I have to justify Arizona School Choice Program, which was first and is, well funded, unless you're the teachers union. So I'll just leave it at that and go back to you, Judge.
We did preempt our local governments in the state to, make ride share available, and then we are supportive. So I jest in the example a little bit, but I'm still going to wait and let them work, to the beta or further models.
Paul, you seem to have an issue with the standard of deference that courts give to legislation, and essentially I think it's a rational basis test. Should the courts presume something differently? Would you advocate that courts presume regulations are irrational until the legislature proves that they're rational, or, and if it's that or anything close to that, how could the legislature engage in lawmaking?
So the presumption of constitutionality or presumption of rationality, you go back and you trace this, it was, the presumption was that there were a set of facts that actually required addressing by the legislature. And that's all it was. It was we're not going to put the burden of production on the legislature in the first instance to act. When they act, we'll assume that they had a reason to act. My argument is, both academically and in the courts, is that that presumption is rebuttable. It must be rebuttable. And the way you would rebut that is by bringing forward contrary facts about, here's the way the regulation works in the real world. They said they were concerned about X. Well, X, as it turns out, isn't a real issue. Or X may be an issue for this sort of thing, but my client does something very different, and therefore that concern of X doesn't apply. It's not an evidentiary fight, but it is there has to be some basis in reality kind of fight. And so professionally, I'm not allowed to impugn the legislature. But I will say, having lobbied in a number of states over the years for all kinds of regulatory reforms, like, some of them are really good, and some of them are not, and some of them have no idea what they're voting on. And so I like this idea that we should be overly deferential to the wisdom of the legislature, I think, has no basis in law or reality. And what we really ought to be doing is setting up an objective, reality-based, what do they think they were doing, and is that actually true? If they came up with a regulatory regime that said, we're doing this because otherwise little green men from Mars will come down here and steal all of our cars, that can't possibly be allowed, rational, reasonable, constitutional. So why can't we fight any sort of regulation that way? Why must we conclusively presume the legislature is right? I just want them to have to do a little bit of homework the same way I have to do a lot of homework when I challenge these things.
The Arizona Attorney General's office has a division of attorneys dedicated to defending state agencies and also state boards and commissions. So, Attorney General, I would presume that your office has such a division, and if so, how does your office go about defending regulations that you might not fully agree with?
Well, it's a good question. I would say part of what we've done is where we find a regulation we have to defend, and absent something violating our Constitution or having some other legal defect, we have a duty to defend it, and we do. But we have recommended many of these professional boards get abolished. So I think there's 3,000 plus professional boards in the state of Florida that regulate various industries. And, it has the advantage of being flexible in nature where, some of these more complex, jobs can change over time, and technology can adjust. They can come back and change those procedures in a more flexible fashion. But we've been working to eliminate them everywhere we can because I just don't think it's always necessary. What I will say is, you ask the best place to regulate. I've said I think it's the states. I do believe it's at the state level and not at the local level. After we fixed everything, in the state government, we then had lots of local governments, cities, municipalities, homeowners associations that would then come in and add their own regulations to thwart what the state was doing or, push another direction. And, I wanted to propose an idea. I don't think it's very popular yet, but maybe I'm just ahead of my time, where if two cities touch, they become one, because we have far too many subdivisions of the state, where you have Florida now as a strong rightward conservative state with strong supermajority Republican legislative chambers. You still have these cities that want to dig their heels in and resist. A good example is immigration. You know, in our immigration enforcement law that we passed a little over a year ago, we kind of suspected that we'd get to a point where mayors and local police chiefs in some of these bigger blue cities would want to be sanctuary jurisdictions and not support the federal government. So we made it law that they have to step up and help if asked. And so we don't have Minnesota chaos in Florida, and where local officials make comments that they're not going to enforce the law, which just happened this morning in Tampa. I write them a nice letter and let them know they're breaking the law, and they might be suspended from office any minute, and nothing gets their attention like losing their job. So I think at the state level, where we can have, you know, boards that either lapse or have to revisit rules on a more frequent basis, we like it, and we defend rules even if we don't like them, as long as they're legally valid, but we'll recommend getting rid of them quite frequently.
So my next question has to do with what I call the growing pains of new technologies or maybe deregulation. One example is from the time Danny and I spent in the governor's administration is there was one time where a driverless vehicle that was being somewhat oversaw in behind the wheel, the person was distracted, I believe, and in the middle of the night, unfortunately, hit a pedestrian, killing this person, and that was quite an event. Also, those of us who are old enough to remember the deregulation of certain utilities and what happened in Texas with a little company called Enron, and how that impacted the availability of electricity, for example, in the state of California. So with that long background introduction, how do we manage the risks of deregulation or the failure to regulate technologies as they're growing? And Professor Selin, maybe you could take this one at the outset.
Yes, I actually appreciate the electricity reference. I think the electric market regulation is fascinating in this regard because it does raise real questions about consequences of deregulation, which sort of follows my remarks. I'll give you an example in addition to the Enron stuff. There is, when the federal government deregulated electric market regulation, ironically, one thing that the Federal Energy Regulatory Commission did was issue 3 orders saying we are no longer going to regulate electric firms, like in electric rate stuff. Instead, we are just market regulators. And those 3 orders actually expanded the Federal Energy Regulatory Commission's authority extensively. They began to do way more than they did before under the guise of deregulatory efforts. And so this really underlies my push to think about the consequences of particular actions. What is the goal of either regulation or deregulation? What are the values that we're serving here? And then what are going to be the real world consequences? How are these markets operating? And what happens if you remove or add in various government actors? And it's my experience, I could go on for ages, but across different economic sectors, it's this consequences thing that really, really matters, and it goes to the question about managing risk. The way we manage risk is to really understand the market and the players involved and how they behave institutionally and what their incentive structures are. If we understand that, we can predict how either regulatory or deregulatory efforts are going to work. And so that's my 2 cents.
Anybody else? Danny, you remember that event?
No, yeah, I remember that well. And no, you described it correctly. It was a Uber self-driving taxi where a gentleman was behind it watching The Voice on his phone when we had our only incident of a lost life due to autonomous vehicles. And we immediately issued an executive order suspending Uber's ability to do self-drive testing in the state, because again, you have to react. But there was political will to keep going. It was political will to allow Waymo and others who were proven to be better actors to continue on at it. And that's kind of what it takes here. If you get into deregulation, you have to really believe in what you're doing. Because I have to tell you, the one thing I haven't seen it in this age of politics or the one before, the willingness to ever say I was wrong or this policy was wrong. And we move backwards, or we admit, or we make changes, and that is unfortunate sometimes. Political legacies are written on sand. The next person who gets elected can change it at a heartbeat, but it's very rare to see someone say, we tried this and it was wrong. So you have to either really believe it, or you maybe have to be that pioneer who's willing to say, this was not the right way to go. And I think dereg of electricity is a really good example. I'm glad that came up as well. As of right now, you happen to be sitting in, I'm not sparring with Florida, but you happen to be sitting in the #1 state when it comes to grid reliability. Arizona is known for our grid reliability. It's a big reason why we've attracted the advanced tech manufacturing and mega projects that we have, because they know that we do not have rolling blackouts. We don't have rolling brownouts. Our grid is all interconnected, it's all managed, it's all regulated. And as a purist sometimes, I used to think that was bad until I saw how it played out in Texas. If you recall, 2 years ago, there was a very bad winter storm. If you're from Texas, I think you more than recall what happened. That was a multi-billion-dollar cost. Loss of lives, yes, but multi-billion-dollar costs to manufacturers. And if you don't think someone like me paid an economic impact study to be developed to show how devastating that was in Texas, you're crazy. I made that. I took it with me to Taiwan and marketed it to every manufacturer I could, just like if something like that happened in Florida, which I'm more partial to because, again, that's my home state where my mom lives. But you have to really pay attention and make sure you know what you're doing is right. Sometimes it can mean, instead of going for the Hail Mary, you're moving the ball down a little bit further down the field. And it's fun to joke and spar a little bit with Florida about school choice. Because, to think 15 years ago, 17 years ago, 18 years ago, when I was the president of this chapter, we had a debate with then Justice Bullock and Paul Bender on Blaine Amendment, just trying to get any school choice to exist. And now we're all bragging about who's got the best universal school choice. And that shows the value of incrementalism, because no matter what I want to take credit for in Arizona, Florida was far ahead of us when it came to school choice for a long time. Governor Jeb Bush was a pioneer when it came to that. So again, I think sometimes there's wisdom, Judge, in going slow, not going for the whole loaf, the third loaf. Make sure you get that policy right, because when you talk about regulations, economic lives and sometimes public safety are at stake. So it has to be done carefully.
So I have one more question for the panel, and then I'm going to open up to the audience. And I want you to all know that the Federalist Society events are very unique and engaging because of audience participation. So if you have a question in a moment, please let us know, and there will be somebody who will get a microphone to you. So my last question has to do with the founders. As the dean mentioned, this is help me out, Judge Johnstone, the semi-sesquicentennial, something like that. Something. Thank you very much. The semi-quincentennial. But 1787 was the year our Constitution was written. Wouldn't you think that the founders, at least at the state level, would think that the states could do essentially what they want? That they were these laboratories of democracy where the state legislatures could choose what they wanted to do concerning regulation and public safety. Do you think that's a legitimate view that the founders might have had, or would they be more inclined to view these ideas of liberty that we've discussed today?
I mean, the founders wrote the phrase pursuit of happiness. If that doesn't include the right to pursue a livelihood, to support yourself and your family, and to live a life that is independent of whatever the state tells you that you have to be doing, I don't know what pursuit of happiness would mean. I think it's absolutely clear, abundantly clear, that the framers of the Declaration of Independence and the Constitution had two ideas in mind. The first was that it was a federal government, not a national government, which meant that states were the repository of most government power, and that just because you were the repository of state government power did not mean you had all the power, that there were large swaths of human life that were beyond the reach of the state. And again, that's what pursuit of happiness historically was meant to, or was understood to be. And so I don't think there's any question that something like the right to pursue your own economic interests in ways that don't harm other people is undeniably there, was understood to be there. And whether you're talking about state regulation or federal regulation, neither one of them can get to the core of your right without a really good reason for doing it, and oftentimes they don't have a really good reason.
You know, Judge, I would, to answer your question, whether or not the founders would agree with that, I think the answer is no. I think we know the founders had a big disagreement on that very topic. I think when you look at who the majority author of the Federalist Papers were, someone who favored, Alexander Hamilton, who favored a very strong central government versus what other ideas that were out there. Now, did they ever think the regulatory state would grow to the point it's at? I'm sure not. But it would be exciting and fun, to really think about what they would think of where we've come to now on the states' rights versus federalism. And again, unfortunately, I would say that we're not too far off from the same debates they were having back then about when is regulation good, when is strong central government good. All these same questions we're debating right now to this day, and grateful for the Federalist Society for keeping this up. It's a worthwhile and relevant topic.
I would say I completely agree. That's the answer is it's complicated. One of the first national laws was a health and safety law to implement quarantining in response to a crisis. That seems, fast forward to today, directly relevant. And so I think there were theoretical discussions that were going on, and then there were practical governance discussions that were going on. And the tension between those two doesn't always line up. I would love to behave a certain way. I have dreams of being the perfect citizen, but in reality, I'm human. And especially when you're talking about collaborative governance and lots of different actors, it is a complicated thing to understand how regulation is working and how the federal and state governments are working together. And I would say that one of the things that sort of came up in our conversation, but I would encourage you all to think about, particularly as you go forward in your own work, one of the reasons that we have these laboratories of democracy is to really reflect variation in constituencies across the country. And being responsive to those constituencies is a core aspect of government. And so I think that while the framers may disagree theoretically about how that was going to happen, I think 100% they would all agree that government should be responsive to its constituents.
I'll definitely agree with Danny on this one. I don't think the founders would have liked to see the broad delegation of authority that the Congress has given to the administrative state. I don't think they'd like seeing members of Congress serving, 30 plus years rather than truly making it a term of public service. The runaway federal spending and the deficit where soon we won't even be able to make the payments on our interest. I mean, I think these are all, things that would have them rolling over in their graves. I think the states need to keep fighting back against federal overreach, where you have, novel new areas of business like, big tech, social media, and especially AI. I think it's important that states step up and try to regulate where Congress is going to have trouble getting things done. It takes one state to bring another state, and before you know it, businesses then don't want to have to be regulated 8 different ways, so they now are motivated to go to DC and negotiate something that'll work across the country. Should we run away from the future? Should we hide from technology? No, it's here. Sometimes I feel like I'm born in the wrong generation, but it's here and can provide great help. I tell people on the conservative side in Florida that are hiding under a rock on AI. I mean, AI is going to do incredible things for government services. Every time we're working on a child pornography case, some prosecutor or investigator has to go through and look at all of this horrific stuff to put the charging documents together, and that takes a real toll on somebody, and burnout is high, and it can mess up your head. So there's AI programs now we're looking at that we need to get, certified for evidentiary purposes. They're going to be able to scan all this and, certify for the purposes of bringing charging documents in court and putting bad guys away. But, as AI gets smarter, what happens when people start directing it to go, build a missile and shoot it at somebody? Or hack into, some other database. Self-policing, yes, people will be trying to do that, but when the incentive is making money, we've seen that companies are going to try to design things that are attractive and addictive, and they're not going to be as concerned about our little ones and our safety as perhaps a state government and more family-run operation. So, thanks for the discussion, and look forward to. We're gonna have some drinks, right? Is that on the table?
Well, let's get some audience questions first. Who has a question out there? Okay, we have some folks up there, or one gentleman.
Thomas Solanover, an evening student at Fordham. I think energy regulation is also emblematic of another problem with regulation, particularly following suit of Wickard v. Filburn. If you look at energy policy, the original actual regulation would regulate the flow of power among states. They would look at the flow on a bus bar. Did power come from New Jersey to New York to see if there was the federal government could regulate it. But if courts, as they have, take such an expansive view that any sort of aggregation can lead to state regulation where, even though the statute hasn't changed, the choosing to not use power now basically gets the federal government involved with demand response cases. Scalia wrote a dissent. And now it's even gone to that through aggregation, your solar on your house could be federally regulated because it could affect the flow of power, interstate commerce, because you are generating some kilowatts on your roof. So regardless if you're going to legislate, if judges are going to read expansive, authority and provisions over and above what's written, how do we protect basically economic actors and citizens from regulation? Sorry.
That's okay. Who wants to take that one?
I'll start. One of the problems when we talk about regulation is that we're almost talking about too much to get our hands around. So far, we've talked about everything from truly like grid level regulation of electrical systems all the way down to who has to have the government's permission to cut your hair. One of the ways that we have to be rethinking this is, again, the question of like, what's the level of regulation, but really what are we regulating? There are some things that, when you're facing it directly as a consumer, when it's right in your face, you are more than capable of dealing with it in a way that maybe I can't conceive of national grid regulation. More to your point now on talking about like the expansion of the federal, this is part of the problem here is that Congress says, oh, this affects interstate regulation and therefore we can regulate it. And then the U.S. Supreme Court has largely said we have to defer to that judgment. Again, speaking as a litigator who sues the government, what I would like to see is judges actually sort of clamping back down on what does it mean to really be in interstate commerce for purposes of keeping the federal government limited to those things it is properly supposed to be regulating, interstate commerce, and out of everything else that it's not supposed to be regulating, and then we can have a debate about whether the state should be regulating it or not.
I would just add, because you brought up rooftop solar, Judge, that at the state level, the reason why we have to be involved is, and you'll often hear this comment from solar lobbyists, is that, well, Arizona has 300 plus days of sun, we should be able to self-generate all our facilities. Well, you know what we also have is 365 nights where there's no sun and darkness. And the grid has to back up those places during that time. So there is an interconnection with the grid that's unavoidable, and that kind of forces the hand of regulation. So we can be accused sometimes of over-regulating, which I hate, because again, in my ivory tower mode, I feel like we should back away completely. But because of that interplay with the grid, it forces us to be involved. I think as technology evolves, it's going to be a much more interesting question when there is storage that can last, and when the technology catches up on this. I think that will continue to change, and the role of the state and the role of the feds will change on that topic.
Well, regretfully, we are out of time. It is 6:30, and as the Attorney General said, I don't want to stand in the way of any post-panel festivities. So let's have a round of applause for these excellent panelists.